News and talk. My name is Jay Edwards here with DeWitt. Just remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office here anytime at 1-800-DeWitt-LAW or interact with the show by sending an email to ask@DeWittLaw.com or by calling and leaving a voicemail at 407-53-MOSES. Every Sunday morning right here, 10 a.m., you'll learn how Florida's legal issues affect you. And with your host and expert, DeWitt of the DeWitt Law Firm, Mo will answer your questions to discuss the latest legal issues affecting the citizens of Central Florida. And I got to tell you, over the last couple of weeks, people have been hitting up that ask@DeWittLaw.com and sending in lots. We got a stack of questions to get to today, Mo.
Big stack today. I don't know if we'll get through them all on.
I love it, though. I love it that people are getting involved. And, every now and again, you want some free legal advice and you don't know where to turn. And you've made this entire hour-long show a place where people of Central Florida can get some great legal advice.
That's the point of the whole show, is to try to, help some people out there and point them in the right direction. And, like you said, this isn't a substitute for sitting down with an attorney, but hopefully we can kind of point you in the right direction and give you a little guidance and help you out.
Right. And, this has happened to a lot of people listening right now and might happen to more in the future. And it just happened to some friends of mine just recently. And I found out that a couple that we've been friends with for quite a long time, they're going to be splitting up. They're going to be getting a divorce. And you just sit in your head and I'm like, what would I even do if this came up? And kind of like, I was like, you know what? I'm just going to ask Mo. When your spouse comes to you and says, I've been thinking about, or I would like to get a divorce, where do you go? What's your first step? What do you even do when something like that happens? Because you're shell-shocked.
Yeah, obviously that can be quite the blow depending on the situation. Some people may be expecting it. Other people, may not see it coming at all.
Mm-hmm.
So the first thing you want to do, obviously, is sit down with an attorney and kind of analyze your situation. So, in certain situations, you may be able to do an uncontested divorce where basically you and your spouse are on good terms and you can sit down and agree to everything. But it's important to memorialize that in writing and do so properly. I've seen a lot of people try to do it on their own and really screw things up, for that lack of a better term. And really some horrific stories where they agreed to everything when they were on good terms. They didn't do it properly, and then things spun out of control later, and they ended up spending years in litigation. I mean, we could do a 5-hour show on all the horror stories I've seen, frankly.
Right.
But so you want to sit down with an attorney and go through basically what is your situation. So you're going to have a consultation with an attorney, and you want to spend some time with them and basically say, okay, we've been married this amount of years. I make this, she makes that. We have this property together, these assets together. We have this debt, these liabilities.
Mm-hmm.
We have kids. We don't have kids, what the age of the kids are. Because basically, as the attorney, what we're going to analyze is what are the issues in the divorce. So, when we're looking at assets and liabilities, that's what we call equitable distribution. So basically, anything that was acquired during the marriage, for the most part, is going to be split equally.
Okay.
There's no real argument over that. Some people say, well, I want 60%. It's like, well, that's nice what you want, but what the law is it's going to be split equally.
Right.
Where people usually argue over equitable distribution is who gets what and what the values of things are. That's really the big argument. So, if you want the house, for instance, you may say, oh, I think the house is worth $300,000. And the other side may say, well, I think it's worth $400,000. So you pay me $200,000, not $150,000.
Right.
So that's where you start going back and forth on the valuations of things. Obviously, cash is easy to value because cash is worth what cash is. But things like real estate, property, when you get into collectibles, we've had cases where people have had, large collections of memorabilia that take, rooms upon rooms in
like
a home.
Sports stuff or
Sports
actor.
memorabilia. Yeah, I'm deliberately not saying what it is just because I don't want it.
Right.
It's a very unique
Sure.
thing. So anyways, I don't want the client to be identified,
Right,
obviously.
right.
Top, we always keep confidentiality here.
Right.
So there we had to bring in an appraiser to appraise those items. And there's of course a situation where do you sell the lot as a bulk? Do you just sell it all together? Or do you sell it individually, which then basically you have to hire somebody because it's a lot of work to sell thousands upon thousands of items. So there's different ways you value things. Of course, if you have a business, you have to value the business. Does it have employees or is it just really you? If it's just really you, then it probably doesn't have a business. But those are all the things we're looking at when we're looking at equitable distribution. From there, we're going to be looking at whether one side's entitled to alimony or not, or if alimony is an issue in the case. So right now, basically, if you're married between 0 and 7 years, that's what we consider a short-term marriage. And depending on the situation, the income disparity, there may or may not be alimony. Obviously, the shorter the marriage, the less likely it is.
Alimony's not always a given, 100%.
Not always a given. If you're married for 6 months or even a couple of years, a lot of times the court, may be unlikely to get alimony.
Okay, I didn't know that. Okay.
The longer the marriage goes on for, the more of an income disparity there is between the parties, the more likely that alimony is going to be awarded.
Mm-hmm.
So typically, I tell people on a short-term marriage, a couple years, 2-3 years, usually the spouse who's seeking alimony probably would just be entitled to a little money to get them back on their feet. Let's say they have to move out, get an apartment,
right,
get a job. It depends on the financial situation, of course. But if you're between 7 and 17 years, that's a midterm marriage. Again, if there's an income disparity, every case is not going to have alimony. But if there's a substantial income disparity where one party makes a lot more than the other, then that party could be entitled to durational alimony, which simply means alimony for a duration of time, for a period of time.
Okay. Is there usually a standard with that, like 5 or 10 or 20 or?
So I usually say most judges do about half the length of the marriage.
Okay.
Now the maximum under the statute is the full length of the marriage. Of course, depending on the situation, it could be longer, it could be shorter. And again, half the length of the marriage is not a rule of thumb by any means. It's just what I've seen a lot of judges do.
Okay.
They kind of just split the baby and say, hey, you've been married 10 years, I'm going to give you 5 years of alimony.
Gotcha.
So, and then of course, there's the famous over 17 years, which entitles you to permanent alimony, which we've been talking about a lot lately this year because there was the alimony reform bill, which was ultimately vetoed by the governor. But if you're married 17 years or more, there is a presumption in favor of permanent alimony, which basically means alimony for life until you retire. You still have a right to modify or terminate the alimony, and you have a right to retire at a reasonable retirement age. And I always use the example of if you're playing in the NBA, you're not going to be playing until you're 65.
Right.
At least nobody has yet. I mean, David Robinson came close, but not quite that far. So it's a reasonable retirement age for your industry, right? So they can't force an NBA player to play till he's 65. But if you're an engineer or a lawyer or a doctor, then 65 is probably a reasonable retirement age. In the flip side, you can't just say, well, I'm going to retire at the age of 40 because I don't want to pay alimony.
Right.
Because then they'll impute income to you, which basically means they're going to pretend that you make the amount of income that you were making for purposes of paying alimony. They don't care where you find the money, but you're going to pay the alimony.
Gotcha.
And if you don't, ultimately you'll end up in jail. So
nice try.
Exactly. So that's the alimony analysis. So far we've gone over, if you're getting a divorce, what is the attorney going to look for? So they're going to look at, again, the assets and liabilities for equitable distribution. They're going to look at the difference in incomes to see if there's a possible alimony case. They're going to see if you have children, what is the time sharing schedule of the parenting plan going to be. Of course, there's going to be child support that's going to go along with that.
Right.
Depending on the schedule is usually the thing that's going to drive most parenting plans. So if you have a parent who's a pilot or a firefighter, the schedule may be a little more chaotic because their schedules are just a little more chaotic.
Sure.
If you're, on the road a lot or traveling a lot, again, same type of thing. Now, again, there's no presumption for 50-50 time sharing in Florida or 50-50 custody. That was part of the alimony reform bill that was ultimately vetoed. But right now, what the court's going to look at is the best interest factors for the children. So the court has to make a determination that the parenting plan or custody schedule that they come up with is in the best interest of the kids or the child. And so they have to go through the factors to do that. Now, while there's no presumption for 50-50 time sharing, I find most judges really want each parent to be involved as much as possible in the child's life, unless there's a reason for that parent not to be. And usually those reasons have to be pretty significant. So it can't be that, dad just feeds the kids peanut butter and jelly sandwiches, and I don't think that's healthy.
Right.
Usually we're looking at, drug or alcohol addiction, physical abuse, mental health issues, stuff that's pretty significant in order for the court to kind of restrict that time sharing. Or, one of the parents is just absent. That's the other big issue. If they don't want to have time sharing or they're absent, the courts typically are not going to force a parent to have time sharing with a child. They want the parent to want to be involved. And so they're not going to force them, but they will still pay child support. And so as we've talked about before, I know we're throwing a lot of information at you in this.
No, but this is all good because it's all kind of like in segments of how it goes along.
Right. And I think it's good for people out there to know, okay, if you are facing a divorce, this is kind of what I need to be thinking. Because a lot of times people come in and they think the lawyer wants to hear your life story of how you met and how you got along and how you don't get along. When the court looks at a divorce, they're looking at it, with the exception of the children, as basically a financial transaction.
Mm-hmm.
I would say it's very similar to, business partners, breaking up a business, because that's really what you've started as a family. You've acquired assets, you've acquired debt, and debt split equally as well. Assets and debt are both split 50-50. So they're just really looking at it as a business transaction. So they don't care really how you got there or who did what or who's at fault. If you live together, you probably have some dirt in each other, and a lot of times people start, slinging mud back and forth. The court does not care about that at all. They're looking at it purely as a business transaction. Now, when it comes to the kids, some of those factors can become an issue, obviously. If one parent's staying out all night partying or, using drugs or something along those lines, obviously that's very relevant to the ability to properly parent a child. But anyways, back to child support. Child support in the state of Florida is simply a formula. So it's based on the income of each party, the number of overnights you have, who pays for the health insurance cost, and if there's any daycare costs, and of course the number of children you have. And basically you plug that into the formula, plug it into the calculator, and it tells you what the child support is. And there's really not much argument there. It's not like alimony where the judge has a lot of discretion or can go back and forth. It just is what it is. And a lot of times, people don't like the number. Frankly, child support's usually not nearly enough to pay for the actual needs of the child.
Right.
And, somebody who has their kids 50% of the time, which makes more money, may be paying way more than maybe they should because they're paying all the expenses for the kids anyway. So it just kind of is what it is. There's a few ways to kind of, look at things and tweak things and make sure it's done properly. I see a lot of times people try to use those online calculators out there and they come in and they say, oh, it says my child support was $10,000. I go, well, I don't think you did it properly, or you missed this or you missed that. It is important, just like any other formula, you have to put the proper information in order to get the proper information out of it. So those are the main factors that we're going to be looking at, kind of analyzing if you're going through the divorce process. Now, the other big issue I always warn people about is, and obviously it depends on how contentious the relationship is. We've talked about some people are able to do an uncontested divorce where basically they can sit down and reach terms and agree upon things. And, one of them hires a lawyer to draft it all up, and the other side has a lawyer review it, and they both sign off on it, and you're good to go and you're divorced. Well, obviously there's the other end of the spectrum as well, where you can't even stand to be in the same house together and things are just extraordinarily volatile. Mm-hmm. And so I always warn people, in that situation, be very cognizant of, domestic violence allegations, because when you're in a volatile situation like that and things get heated, all it takes is an accusation that can really ruin one party's life. Certainly don't commit domestic violence.
Sure. Right. Yeah.
But be cognizant of, if it's a volatile situation, you have the ability to move out, get your own apartment, move out of your own place, stay with family or friends. That may be the best situation for you because, once domestic violence allegations come about, typically it's going to involve an arrest. It's going to involve a domestic violence injunction.
Your kids now,
your kids, you may not be able to see your kids for an extended period of time. It could affect your work, depending on what kind of work you do. I've had people who have had high security clearances who've had to go through a whole rigmarole with that. So you really want to be cognizant of that. I would say the best way to deal with any potential of that is to avoid it altogether. So if you're able to move out, if it's a volatile situation, I think that's always the best thing to do. Obviously, financially, not everybody can afford to do that. And in those situations, it could be a little tricky. You want to try to give yourself as much space as possible. I've had people move into other sides of the house or other rooms in the home and try to keep their separate space and not interact with the other spouse.
But sometimes it's hard not to do that.
It can be very, very tough. And I could, spend a few hours telling you horror stories of people who've had to deal with things in that situation as well. But in general, in kind of a nutshell, that's what the attorney is going to be looking at. Okay. But you want to get some advice early on, even if you're not ready to hire the attorney yet. Get some advice so they can guide you through the process. That's the most important thing.
That's some great advice right there. And you can always get that advice if you want to call the office anytime at 1-800-DeWitt Law, DEWITT Law, 1-800-DeWitt Law. And we're going to be taking some of your questions coming up here in just a few minutes. If you want to get yours in, whether it's for today or next weekend or the weekend after that, you can always send that email with your question to and some advice to ask@DeWittLaw.com. ask@DeWittLaw.com, or you can also call and leave a voicemail, and we'll get your question right there at 407-53 Moses. More with the DeWitt Law Review coming up on 107.3 FM and AM 580, Orlando's News and Talk.
I had stopped, and for some reason I look up and I see the headlights coming up, and I knew he wasn't gonna stop. I'm just sitting there bracing for it, and sure enough, bam. And a couple days later, I woke up and said, oh no, my neck was hurting, back is hurting, and I felt hopeless. I didn't know what to do because I thought it was over. Maybe in that moment, was I supposed to call someone? At this point, is it too late? And I went on the internet. First thing that pops up is DeWitt. And I said, okay, I'll give him a call. We'll see what happens. I don't know about lawyers, because I was the same person. I was afraid of it, to be honest. I thought maybe I'd have to pay them if I lost. Like, I just didn't know how it worked. I think the biggest thing that I can say that DeWitt helped me with was holding my hand through the process of treatment. They actually were able to refer doctors to go to. I got help with my MRIs, with all the scans we had to do on the neck. So there was so much that goes into a car crash process that I truly just didn't know. If you've been hit, call. Simple as that. Because you don't have to do it alone. There's people like the DeWitt Law Firm that will help. If you're injured on the go, just call Mo.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards, here with Mo DeWitt. All right, Mo, we were just kind of talking about divorce and what happens if your spouse brings it up and says, this is something that I want to do, and some great advice that you just gave us. And a couple questions that I had while we were talking were, you were talking about child support.
Right.
Does child support automatically end when your kid turns 18?
So it ends when your kid, in most cases, is going to end when your child graduates from high school. So typically if they're 18 and they're still in high school with the expectation that they graduate before they're 19, it's going to go to their graduation date.
Okay.
Or it can go until they turn 19. If they're still in high school, then it'll terminate when they're 19 if they haven't graduated yet.
Gotcha.
However, in certain situations, if your child has a disability, then it can go forever, basically.
Okay.
And those are really supposed to be in kind of extreme disability cases where basically the child has to be taken care of forever. So that's kind of the only real exception to that. But typically in most situations, it's going to go towards 18 if the child's already graduated high school, or if they're still in high school with a reasonable expectation that they graduate before they're 19, then it will stop on their graduation date. But one thing to note is when you draft a marital settlement agreements or final judgments of divorce, one thing a lot of people used to not do for some reason is actually put what that date is. And what happens is the court doesn't put it in their system. So I've had people who've continued to pay child support until the kid was 21 because it was just coming out of their paycheck and they didn't know how to stop it, and the court didn't stop it. And so then it's a whole mess. You have to go and get the order to stop it, which is fairly easy. But in most cases, that money's kind of gone and you're not really going to get it back.
Okay.
So unless there's another child where you can offset it, and it becomes a little complicated there. So just a note, if there's an actual graduation date, put the graduation date, or if there's a birthday or whatever the actual date is that it should stop.
Okay, gotcha.
Yeah.
All right. Now, what about alimony? Does that automatically stop? Say, your ex gets remarried. Does alimony stop on that day of their new marriage?
In most cases, it will. So under Florida law, basically alimony stops upon death, remarriage, cohabitation. Those are kind of the big ones there. And we should probably talk about cohabitation later because it doesn't exactly mean what you think it means.
Okay.
But yeah, if the spouse who's receiving alimony gets remarried, the alimony is supposed to stop. Now, obviously, if the spouse who's paying alimony, I've had someone try to argue this to me before. If the spouse that's paying alimony gets remarried, it does nothing.
Okay.
So you still have to pay the alimony to your ex.
Because that person's still single and still needs the help.
Exactly.
Nice try.
Nice try. Now, the only exception to that is sometimes people will make alimony what we call non-modifiable, meaning that it cannot be modified in any situation whatsoever. And so usually we'll do that. And let's say we're instead of paying 10 years of alimony, we're going to pay 3 years, and maybe it's going to be a little bit higher, but we're going to say it's non-modifiable, meaning if you lose your job, no matter what happens, basically the other party is going to get paid. And so now I've also had people where they try to slip in some non-modifiable language and they don't really explain that to the other side. So something to be very careful about. And again, this is why you want an attorney reviewing these agreements, whether it's me or somebody else, just have an attorney review it. Because I'll tell this one story. I think we have a little bit of time. I had a guy who he was married about 3 years. He was trying to be a nice guy. They got divorced, and he agreed to pay 10 years of alimony. And his wife basically said, oh, yeah, I won't really enforce this. Just pay me some money, get back on my feet. And the agreement that he signed said 10 years non-modifiable alimony. Now he got remarried, and his new wife said, where's all the money going?
Right,
What are you doing here? And they brought the agreement to me. I go, you're basically stuck. Once it's signed, once it's ordered by a court, there's really nothing you can do. You cannot modify this. Even if you lost your job and you're homeless on the street, the court still says you have to pay it because it's non-modifiable. So, there's a lot of technical little terms like that people can try to slip in that you really want to be informed about, that you really want to know what they mean and how they're going to affect you down the road.
Yeah, because 8 years later, that could come back to bite you.
Oh, absolutely. Yeah.
All right.
Paying 10 years of alimony on a 3-year marriage, no judge would ever order that, in my opinion.
Gotcha. All right. Well, we're going to talk for a minute about what cohabitating means, because in my mind, I think I know what it means, but I have a feeling I'm going to be 100% wrong on this one. So more coming up on the DeWitt Law Review in just a few minutes on 107.3 FM and AM 580, Orlando's News and Talk. And we'll get to your questions too. You still got time to send one in if you want. ask@dewittlaw.com, or you can leave a voicemail by calling 407-53-MOSES.
So I want to show you something. Here, come closer. See this letter here? This letter offered for our client to settle for $10,000 back in May of 2021. We just got this client $200,000 for that same accident. He didn't want to take the $10,000, and rightfully so, because the insurance company was offering him pennies on the dollar. Oftentimes, clients get impatient, but in this case, it was worth the wait and worth to fight the insurance company to get what he deserved. Injured on the go? Just call Mo.
You've been listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk, here with Mo DeWitt. It is the DeWitt Law Review. For legal advice, you can call the office anytime at 1-800-DeWitt-LAW, DEWITT, 1-800-DeWitt-LAW, or you can interact with the show by sending an email to ask@dewittlaw.com, or also leaving a voicemail. We'll get to it and get your question on the air at 407-53-MOSES, and we have some of those questions, some good ones today coming up in just a few minutes. But we were talking just a minute ago about alimony and when it stops, and it stops with death. You get remarried or cohabitation, because
right. Cohabitation is one of the reasons that you can modify or possibly terminate alimony.
Can I guess?
Yeah, go ahead.
You find somebody new, you move in with them.
Well, that's what you would think it means. But
okay. I knew I was going to be wrong.
but really what the court's trying to do here is they're looking at situations where people are basically living together like their husband and wife, like their spouses, but they're deliberately not getting married to continue to receive the alimony. So,
I gotcha. So you're double dipping.
You're double dipping. So sometimes this can get a little more complicated than one would think, because it's not just that you're living together as roommates, right? You can have a roommate and that doesn't typically terminate alimony. There's one funny case out there where I think it was the lady went to jail for DUI manslaughter, and the court said, oh, you're cohabitating now, so I'm going to terminate your alimony, because she was receiving alimony from her ex-husband. So that's one kind of off the wall case. But in most cases, it doesn't just mean because you have a roommate. Basically, you have to be in a financially supportive relationship, just like you would be, as a married couple. You're just not getting married in order to keep receiving that alimony. That's the whole purpose of the cohabitation under the current statute. Now, where that becomes a little bit complicated is sometimes you have to dig into financial records. You have to show that their bank accounts are joint, or they're sharing in what we would normally be considered marital expenses. Basically that they're kind of supporting each other in that regard. So, where that gets complicated is where maybe they still have two separate residences, even though they spend every night at one residence. But when you file for that modification, they're going to say, no, I maintain my own home. I just come over here, a couple nights a week, things like that.
Gotcha.
That's where it can get a little gray, and really you have to dig in and do, some financial discovery to see what's really going on. And obviously that kind of information is tough to get before you file the modification action. So a lot of times you observe something, you you see the other spouse there, the new spouse there. Every time you go there and you say, oh, these people must be living together, I should file a modification action. Then you file and they act like you're crazy. Oh, no, I got my own house. I got my own expenses. I don't pay anything over here. And so that's where you really have to do some digging and sometimes even get an investigator involved to really dig through some stuff to see what's going on.
Gotcha. Okay. Yeah, I knew I was going to be wrong. Kind of like the Goldie Hawn, Kurt Russell. They've been together for like 30 years, but they're not technically married by law. But in some situation like that, you could kind of prove that, hey, they're cohabited.
Right there, I'm sure they have intertwined bank accounts and they're sharing homes together and expenses and all that kind of stuff. So yeah, that would be cohabitation. The one thing I also wanted to mention, a lot of times people will ask, in a divorce, can the other side, let's say one side makes more money, can the side that makes more money pay my attorney's fees? And so attorney's fees are the same standard as alimony in Florida. It's need and ability to pay. So if you have the need for them to contribute to your attorney's fees, and that side has the ability to pay to contribute to your attorney's fees, then you could have a claim that they reimburse you for your attorney's fees. Typically, whatever attorney you hire is still going to make you pay the retainer up front, and then they're going to ask to collect it from the other side. So maybe you have to put it on a credit card, then you go and file a motion for temporary relief and ask that the other side, contribute to your attorney's fees. Now, just like alimony, the judge has a lot of discretion there. There's never any guarantee that it's going to be awarded, but that's the analysis. It's simply need and ability to pay.
So somebody's making $250 a year, somebody else is making $35 a year.
Right.
They might side in the favor to help you out with those attorney's fees.
Right. Or you have the situation where, maybe one party stayed home and took care of the kids. The other party worked and has a substantial income. That's where you're going to be looking for that contribution to attorney's fees. And that can even still happen on short-term marriages sometimes, because the court does want to make sure that both side has equal access to counsel. Gotcha. And so I say equal because sometimes, you'll get one party who will say, oh, I need $50,000 in attorney's fees. And the guy, the other side who has all the money says, well, I only spent $5,000. Why do you need $50,000?
Right.
So it's equal. They're supposed to be equal. It's not, some open door to just spend as much money on attorney's fees as you want. It's supposed to ensure equal opportunity to counsel to get the advice that you need to go through the divorce.
Gotcha. All right. So we've been covering child support. We've been talking about alimony, and some of the questions that are coming into us at ask@DeWittLaw.com happen to deal with these subjects. So I figured let's go ahead and knock some of these out.
Why not?
Get to some of your listener questions. So this first one is, my stepdaughter, 17 years old, was kicked out by her mother, and now she lives with her grandmother. And her mom didn't notify the court about this information, that she's now living with grandmother. And my husband is still having child support removed from his paycheck. So she wants to know, is it illegal for the mom to continue to collect this money when the child isn't even living there? And how do we go about cutting it off, or just have it directly transferred to the child so mom doesn't have it when the kid's not even living there?
So in most cases, the court's not going to give the child support directly to the child. Usually it goes towards the parent or guardian who is actually taking care of the child. Now, in this situation, the most important thing for the person who's paying the child support to do is to file a modification action right away. Because once you file the modification action, it does a couple things. Number one, the court can go back to the date that you filed the action to modify the child support.
Okay.
Typically, it's going to be hard for them to go back beyond that date to actually modify the child support.
So the sooner you do it, the better off you are, because it'll be cumulative from back then.
Exactly.
Okay.
So you want to file that right away. Now, the other thing that it helps with is once you file that, under the current case law, the court cannot hold you in contempt of court for not paying the child support. So once you file it, you could stop paying the child support to the mother, with the understanding that maybe you have to pay it to the grandmother down the road. It's not a get out of jail free ticket. You don't just get to stop paying it, but they can't hold you in contempt of court for that period of time until it's figured out down the road. So typically I'd recommend in a situation like this, if they want to stop paying it to the mother, they put that money in a separate account, put it in every month, so that the court does award it to the grandmother or somebody else. You already have it there, and you're not going to have an arrearage issue.
Gotcha.
Now, typically, it's probably not illegal for the mother to continue to receive it. There may be some unjust enrichment issues there. Or she may have to pay it back in the end.
It's just wrong.
Since she doesn't have the child anymore. Exactly. I mean, it's more of an ethical, moral issue rather than actual crime, so to speak. But typically that's going to be the way you want to go about it. You want to file that modification action right away, get that in the court system, have that heard, and basically say, hey, Your Honor, they don't have the child anymore. Grandmother's taking care of the child, or maybe the child comes back to you and lives with you. But certainly the mother's not going to be entitled to child support. because she doesn't have the child. Because remember, one of the biggest factors for child support is the number of overnights that you have the child. It's not days in Florida. It's actually overnights.
Okay.
So that's another area I've had people kind of get tripped up on before is they'll say, my daughter really likes staying at her mom's house. She's got a great bedroom there. So I'll just, in the parenting plan, I'll just do where if she comes over after school, she stays at my house till 8, 9 o'clock at night, but then goes home, to mom's house to sleep, and then wakes up, goes to school the next day and does the same thing.
Mm.
So they're seeing the child every day, but then their child support is going to be extremely high because they have no overnights.
So you got 7 nights a week. So even though your kid's there majority of the day after, wow, okay.
Yeah, because it goes by the actual overnight that's listed in the child support formula. So, and if you have less than 73 overnights a year or less than 20% of overnights a year, for child support purposes, they assume that you have 0 overnights. So, first of all, you have to get over that 20%, but also it goes by overnights, not by hours during the day or anything like that. So, that's just another little trick. But anyways, that's one of the biggest factors when you calculate child support. So in this question, obviously the mother no longer has any overnights if the child's not staying there anymore. So she would not be entitled to child support.
Yeah, grandma should be getting that money.
Right.
I mean, ultimately, it needs to go to the 17-year-old to help take care of that kid.
Well, that's the purpose of the child support. And that's why in Florida, at least, you typically cannot waive child support as the parent. A lot of times parents will say, oh, I agree to not pay any child support. I agree to not come after you for child support. That's really not enforceable in most situations, especially if it's not written up properly.
Okay.
Because the child support is for the benefit of the minor child. So the parents can't just waive it. Sometimes the court will allow them to do something where, maybe you're paying some other expense in lieu of child support. Maybe it's, private school, or you're paying for travel costs or something along those lines. In some situations, the court may allow you to waive it then when you're paying another cost. Or if child support is de minimis, basically under $50, the court there will basically say it's de minimis, will allow you to waive it. But typically you cannot just waive child support because you want to.
Gotcha.
So I actually had somebody, I think they were on the show at some point, was telling a story where, their parents got divorced, and dad would send mom a check for $400 every month, and then mom would just send it back to dad because it had to go through the child support system. And basically they had an agreement amongst themselves that they wouldn't seek child support. So dad would write a check to child support. It would go to mom. Mom would write the check back to dad, and that's how they did it for years.
Still just following the rules, though.
Yep, they were following the rules.
Oh, that's great. But it's awesome that they made that agreement and they stuck to that agreement,
Yeah. I mean, obviously, if mom decided at a certain point not to give it back, there would be nothing dad could do about it.
Right.
But that's what they did. And I guess it worked for them,
Perfect. Yeah.
their situation.
Whatever works for each couple, right?
Yep.
All right, we got a couple of minutes. Let me try and get to this one real quick. I have 2 kids with a man. I have 2 kids with a man I was with almost 4 years ago. We were never married, and since then I've gotten married, and I have a new daughter with my husband. I have had no contact with the older 2 kids' father. He periodically pays some child support, but still owes us thousands of dollars in back child support. He hasn't reached out about the kids in the last 2 years, hasn't seen them in 4 years. And I was wondering what the best course of action would be for my family. Do we apply to have sole physical custody or try to get his rights taken away?
So a lot to unpack in that question, but basically, so let's start with the termination of parental rights. So that's one of the questions they ask is, can you terminate his rights? And typically, unless the dad here consents, it's usually pretty hard to terminate someone's parental rights. The only way you can really do it is if you can show that that person has abandoned, abused, or neglected the child. So here in this situation, you would have to argue abandonment. And so they say he hasn't had anything to do with the kids in about 2 years. I think the kids are about 4 years old from what they say. But he is still sending some child support here and there. So, depending on the actual facts, the actual circumstances, and if the father even were to show up to the proceedings, would dictate whether the court would ultimately terminate his parental rights.
Okay.
So, I've had in these kind of situations, you really don't know how dad is going to react when someone tries to terminate their parental rights.
Sure, yeah.
In some situations, dad says, hey, I don't want to pay child support. I'll terminate my parental rights. Great. That gets me off the hook for child support, because once your parental rights are terminated, you don't pay child support anymore.
Okay.
Other times, the dad will say, absolutely not.
Still my kids.
Yeah, it's still my kids. And a lot of times they say, well, the only reason I'm not being able to see my kids is because mom's not letting me. So I've seen both sides of that situation.
Okay.
And so if he shows up to court and says, hey, I absolutely want to see my kids. I've been sending money. I've been trying to see them. Mom's not letting me. that's a very different situation.
Okay.
So there's always, two sides to the story, obviously. Now, as far as the other aspect about sole parental custody, well, in order to have any sort of time sharing agreement here, you'd have to file a petition for paternity. Because right now, as we've said before, even if dad's listed on the birth certificate in Florida, until a court adjudicates him as the father, he has no legal rights to the children.
Okay.
So right now, mom basically has sole parental custody because there's no court order adjudicating him as the father. So in this situation, it might be better for mom to just, if she wants complete control over the time sharing schedule, the custody situation, maybe she just leaves things as the status quo is, basically.
Right.
Now, that being said, there may not be a court order for child support if she wants child support. In this situation, from the question, we don't know if he's just kind of voluntarily sending a few bucks here and there as child support, or there may be a Department of Revenue action where child support was awarded and not time sharing. That action may have adjudicated him already as the father. We'd have to look at it. So there's, again, a lot to unpack here. But, I think that's something, if they're looking to terminate his parental rights, if you know where he is, if you ever talk to him, typically it's better to have that conversation first and see what the reaction is before you go down the path of actually filing the action, only for him to show up and say, no, absolutely, I want my rights, and I want time sharing, I want this, and I want that.
Save you a little time and money in the long run.
Time, money, and headache. A conversation in a lot of situations can point you in the right direction and just save you a lot of them. A lot of headache. Yep.
There you go. All right, we'll get to more of your questions. So, plus, we've got our Mo Pro Tip of the Week coming up in just a few minutes. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
About a year ago, I was in a really bad accident. I got my hand caught in a saw and I lost my thumb. Luckily, the doctors were able to put everything back together. Originally, we reached out to other firms to take my case and nobody would help us. But when we called Mr. DeWitt and his team, they were there to help through the whole thing. I'm extremely happy with the result. Extremely happy with the result. It was an easy process. They made it as easy as possible and we got the best possible result. Injured on the go? Just call Mo.
Hey, thanks so much for joining us for the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards here with Mo DeWitt. You can always call the office if you need legal advice anytime, 1-800-DeWitt-LAW, or if you have a question for the show, which we'll get to one here in just a second, ask@dewittlaw.com. All right, our Mo Pro Tip of the Week coming up in just a second, but first, let's get to another listener question. It's from Don. He says, I was in an accident. It was my fault. No injuries, full coverage on both vehicles, and I have it on dash cam. If I end up getting sued, does the insurance company handle it, or do I need to get my own attorney?
Well, Don sounds like a very well-prepared individual, which I appreciate. And dash cams are great. Evidence. Yeah, I wish every car had a camera on it because it makes everybody's life easier in some sense because you can see what actually happened. And if you've ever seen Teslas, I've had some accident cases involving Teslas. They have cameras basically all around the vehicle, which makes kind of watching the crash. I mean, to me, pretty cool. Obviously, not to everybody, but it's great documentation to show exactly what happened, how the hit occurred, how hard it was, and even sometimes what speed they were going at.
Right.
So obviously, dash cam evidence is great. Now, in this situation, Don was at fault. So, typically, he's going to need to report that to his insurance company right away, let them know you have the dash cam video because they'll want to see that,
right?
Especially if it does lead to a lawsuit, because that may be evidence. Because if the other side is over exaggerating injuries or saying that the accident happened in a different way, I've seen all sorts of things happen before in accident cases, and video footage is the most useful footage possible. Now, also, I mean, as we know, studies show us eyewitnesses are just not that reliable in general. So that's another reason that video evidence can be helpful. And if the case does ultimately end up in a lawsuit or end up in court, of course, your insurance company is going to want to use that evidence as part of their case, most likely. Or somebody's going to want to use it, whether it's good or bad, I guess. Depends which side's going to want to use it. But it's great information to have. But yes, to answer the question, typically in these situations, if you have insurance on your vehicle and you're in an accident and you do get sued, typically the insurance company is going to step in and defend you. However, one thing I get complaints about from people all the time is, well, the insurance company paid out money on this claim. I didn't think they should have, or they paid out too much money, or things like that. Well, ultimately, it's the insurance company's money. It's typically the insurance company's choice as to what they want to pay on.
Right. Yeah.
Now, especially up to the policy limit. When you start going over policy limits, there's all sorts of factors that come into play, and we can do a whole nother show on that another day. But, a lot of times people will say, well, I'm not happy with what they paid. I think they paid too much. Now my rates are going up. Honestly, that's just kind of part of insurance. It's their money. They get to make that determination. While you do have to cooperate with the process, give them the information, sit for depositions, attend mediation, all that kind of fun stuff. Ultimately, if they think you're at fault, and if there's, injuries or significant injuries, they're going to pay out some money, and that's going to go against your driving record because you were at fault, and your insurance rates may go up from there. And you might be taking a little hit on the insurance market for a few years there. But it's great that you have the dash cam, something I recommend everybody have. I think we'll start seeing that built into cars more and more, hopefully. Yeah. But it's just great evidence, great information. And a lot of times I've had cases where it really does protect people. And I've had cases too where the party was not involved in the accident at all, but caught it on dash cam. It was nice enough to pull over and say, hey, I caught this accident on dash cam.
That's true.
If you
Yeah.
need the video, here's my number. Let me know. So that you have the evidence, you have the proof. And actually, in the case I'm thinking of, it was a semi truck who kind of took a corner too sharply and basically ran over a vehicle. That's the only way I can kind of say it. And then denied that they hit the vehicle.
Oh my gosh! And somebody else captured
Somebody
it?
else had the dash cam video.
I think actually there's your Mo Pro tip of the week right there.
There you go. Get yourself a dash cam.
Can't hurt to have a dash cam.
Yep.
Like it might save you, or helping out somebody else.
You never know. But I'll do a quick pro tip if we have time.
We got just a few seconds.
All right, so I'll make it super quick. One we've done 100 times. Check your insurance policy. Make sure you have uninsured motorist coverage on that policy. There are so many drivers in Florida driving with the bare minimum insurance or not having insurance at all.
Mm-hmm.
If you do get hit and you do get hurt, you want to have that uninsured motorist coverage. I've had hundreds of clients who have benefited from it. And I think they would all swear by it at this point because that was kind of their saving grace.
I took your tip and I found out that I did not have it a few weeks ago, and I added it to my insurance, and it was not much at all.
It's not much at all. Nope. Most people, like you said, don't even know if they have it.
I had no idea.
Exactly.
There you go. Your Mo Pro tip of the week. If you have questions, legal advice, you need it, you can call 1-800-DeWitt Law or interact with the show. We'll get to your questions next week. Ask at DeWittLaw.com. You've been listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando.